Imagine paying your hospital bill, not once, but twice, providing proof of payment 3 separate times, getting sent to collections anyway, and then finally discovering that your money was credited to a completely different person's account. A stranger, someone who has never even set foot in that hospital. And the hospital's excuse? They thought it might have been your husband. That is not a billing glitch. That is a nightmare. And it is exactly what happened to one woman in South Carolina, and the legal implications go far deeper than $90. Let's talk about what really happened here, what laws may have been broken, and what you should do if you ever find yourself in a situation like this. So here is the setup. A woman in South Carolina had a medical procedure done. Then, 2 weeks later, she had the exact same procedure done, again at the same location for the same cost. She paid for both through her FSA, that's a flexible spending account, a pre-tax account many people use to cover qualified medical expenses. Each procedure was its own line item. Each was paid in full, clean, simple, documented. Then about a month after the second procedure, the hospital sends her an invoice. They are billing her as if she never paid for one of the procedures. She is not panicking yet. She has proof. She pulls her FSA payment records, which also show that the hospital cashed both checks. She sends it in, and here is where things start getting strange. Nothing happens. So she calls, she sends the proof again, nothing. She calls again, sends the proof again, still nothing. After the third round of calls and documentation, the hospital finally does something, but not what she asked. Instead of applying her full payment of $167, they only applied $77 to her account, leaving a supposed balance of $90 on a bill she had already paid in full. At this point, months have passed. She is deep into what should have been a simple administrative fix, and instead she is stuck in a loop of phone calls, documentation, and zero accountability. Then it gets worse. The procedure happened in August. By February of the following year, that is roughly 6 months later, she starts receiving calls from a debt collection agency. At first she thinks it is a scam. Most of us would. But then the letter arrives, a formal debt collection notice for the $90 the hospital claims she still owes. Now, there is actually a right way to respond to a debt collection letter, and she did exactly that. She sent a certified letter back to the collectors requesting debt validation. This is a right protected under the Fair Debt Collection Practices Act, the FDCPA. When you request validation, the collector is required to stop collection activity until they can verify the debt is legitimate and that you actually owe it. She included her printed proof of payment. The calls stopped, the letters stopped, the collectors went quiet. But the underlying problem with the hospital? Still not resolved. She also filed a complaint with her state's Consumer Financial Protection Agency. They acknowledged it, asked for documentation, she sent it, and then crickets. No updates, no resolution, just more waiting. So now she is making yet another round of calls to the hospital billing department, and she finally gets someone who decides to actually dig into the records. This person calls her back, and what they find is almost unbelievable. The hospital traced her payment. They found it. And here is where it gets genuinely alarming. Her payment, the money she submitted from her FSA for her own procedure, had been credited to someone else's account, a stranger. Not only that, it had been credited twice to this other person's account, once for a previous payment and once for hers. When our patient pointed out that this could not possibly be her husband's account, because her husband has never been to this hospital and does not have an account there, the billing representative confirmed it. The name did not match. The date of birth did not match. This was a completely unrelated third party who had just received credit on their medical account using her money. The representative apologized, said she would escalate it as a priority, and ended the call. And now our patient is left asking the question that brought her to the internet for help. What do I even do here? Let's break this down, because there are actually several distinct legal issues at play, and understanding them matters. The first issue is straightforward billing negligence. The hospital accepted her payments, cashed the checks, and then failed to apply them correctly. That alone is a consumer protection issue. Sending someone to collections over a debt they do not owe, when you have documentation proving it, is a serious problem. Depending on the circumstances, it may be a violation of the Fair Debt Collection Practices Act if the hospital knew the debt was disputed and sent it to collections anyway, or if the collector continued pursuing it without proper validation. The second issue is the privacy violation. This is the one that should make everyone stop and pay attention. Her payment information, her account, her financial data, her identity, was linked to a completely different patient's account. That is a potential violation of HIPAA, the Health Insurance Portability and Accountability Act. HIPAA protects not just your medical records, but also the financial information associated with your medical treatment. If the hospital accessed, modified, or mixed her financial account information with another patient's records, that could constitute an impermissible disclosure or a breach of protected health information. Now, individuals cannot directly sue under HIPAA. That is a common misconception. HIPAA complaints go through the Office for Civil Rights within the Department of Health and Human Services. But a HIPAA violation can support other legal claims, and regulators can impose significant fines on healthcare providers who mishandle patient information. Third, there's the question of the money itself. Her funds were literally applied to a stranger's account. That is misappropriation of payment. Whether it rises to the level of a legal claim depends on the specifics, but at minimum it is a billing error the hospital is obligated to correct. At maximum, if this is a pattern of behavior, it could support larger regulatory or class action scrutiny. So what should she actually do? And what should you do if something like this happens to you? Step 1. Document everything obsessively. She is already doing this, and it is the right call. Every call you make, write down the date, time, the name of the person you spoke with, and what was said. Keep every letter. Send important correspondence by certified mail so you have proof of delivery. She did this with the debt collectors, and it worked. Step 2. Put it in writing to the hospital. Phone calls are not enough when you are dealing with a billing dispute this complex. Send a formal written dispute to the hospital's billing department and their patient advocate or patient relations office. Reference the specific payments, the dates, and the fact that your funds were applied to an unrelated third party's account. Use the words written dispute and reference your rights as a patient and consumer. Step 3. File a HIPAA complaint. She should go to the HHS Office for Civil Rights website and file a complaint about the privacy breach. Her payment data being linked to a stranger's account is a reportable incident. The hospital is required to have breach notification procedures. Whether they followed them or not is something regulators can look into. Step 4. Contact your state attorney general's Consumer Protection Office. She already filed with a state consumer agency, which is great, but the attorney general's office is another avenue. They have enforcement authority, and hospitals tend to move faster when a state AG is involved. Step 5. Consult a consumer protection attorney. Many attorneys who specialize in FDCPA violations or healthcare billing disputes offer free consultations. Given that she was sent to collections over a debt she did not owe, and that her money was misapplied to a stranger's account, she may have actual claims worth pursuing. Not just for the $90, but for the stress, the time, and potentially statutory damages under consumer protection law. The FDCPA, for example, allows consumers to sue debt collectors for up to $1,000 in statutory damages per violation, plus actual damages and attorney's fees. That changes the math significantly. Step 6. Escalate within the hospital. She asked for this to be escalated, and that is right. But if the escalation goes quiet, she should ask to speak with the chief compliance officer or the hospital's privacy officer specifically. Those are the people whose jobs depend on HIPAA compliance. They respond differently than billing departments. The bottom line here is that this woman did nearly everything right. She kept proof. She sent certified letters. She filed complaints. She pushed back on collections correctly. What she may not realize is that the situation she is in, money credited to a stranger, her identity linked to another patient's account, sent to collections while actively disputing, is not just a frustrating inconvenience. It is a set of facts that a consumer protection attorney would find interesting. The $90 is almost beside the point now. If this has happened to you, If you have paid a medical bill and had it mysteriously unapplied, if you have been sent to collections over a debt you dispute, or if you have reason to believe your billing information was mixed up with another patient, do not just keep calling the same billing department and hoping someone figures it out. Request everything in writing, file formal complaints, and talk to a consumer protection attorney, because what feels like a billing mistake might actually be something the law has specific remedies for. If you found this video helpful, consider subscribing. We break down real legal situations in plain language every week, because understanding your rights is the first step to protecting them.